Hello, this is Attorney Tanya Ballard. Today I wanted to talk to you about what to expect when you bring a personal injury case or you contact an attorney to help you with an injury that you have that was caused by someone else. There are several stages to it, and not that often, but some clients want to know why it's not happening right away. So what I wanted to do is tell you a little bit about the different stages of an injury claim. And I like to think of it as 8 different stages. And in this message today, I'm just going to talk about the first 4. So let me just give an overview of the 8 stages. The first stage is the investigation stage, so you contact us and we investigate the claim. The second stage is after we've gathered all of our evidence, then we make a settlement demand on the other side, the party who has caused the injury, and usually it's an insurance company that represents them in the beginning, and we will make our settlement demand to them, show them all of our evidence, and show them the proof of the injury that you've had. So that's the second stage, the settlement demand stage. And so we go back and forth on negotiation, but I'll come back to that. The third stage is when, if we're not able to settle, we actually file the lawsuit, go forward with the lawsuit. And it's not just us filing a paper, it's the other side answering. And I'll go into a little bit more detail on that in a minute. The fourth stage during the lawsuit is the discovery phase, where both sides are exchanging evidence and seeking evidence from the other side. The fifth stage is right before trial. There are a series of motions, and it's quite a lot of labor that we put into those. We want the court to do certain things, the other side wants the court to do other things. And so that's all before trial. Then there's the seventh stage, which is the actual trial. And then after the trial is over, if there are any bases for appeal, I would call that the eighth stage, the appellate stage. And we don't do appeals, but if we think that there's a basis for it, we refer that out. So those are the 8 stages. So let's start back at the beginning. I'm just going to cover the first 4 today. The first one is the investigation stage. So you contact us and you give us enough information so that we think that, yeah, hey, probably somebody was negligent or worse here. And so we'll go ahead and take the case, take your claim, and we'll begin investigating, because we can't just ask the other side for money. That's not fair. Can you imagine being on the other side? Somebody just sends you a letter and says, hey, you did this wrong and we want money. No, they want to know why they're responsible. So we work on the why. We do an investigation. We gather your medical records. That takes quite a bit of time to get medical records, believe it or not. HIPAA provides that the medical provider should give you any records of theirs that relate to you, or to your representative, which would be the law firm that you hire. And sometimes it's really difficult to get those. It just takes a long time. And we're also investigating the claim, seeing what further evidence there is. For instance, if it's an auto accident, we get the police report. We try to interview witnesses to see that we can prove your claim. So there's that period. Also, we don't move into the next phase to make a settlement demand until you are actually finished treating to sort of a stationary level where you're not getting any better. And at that point, we will have the evidence and we'll make our settlement demand. And so then that moves us into phase number 2. And I call it a phase because it's actually, we write up these settlement demands. We write up a new one for every single case. So it's not like I can use the case that I did before and use it for yours. No, every fact pattern is slightly different, although they do fit into some patterns, but they're never the same. So we write up the settlement demand and we present it to the other side. If there's any hint of liability on the other side or potential for liability, then we kind of go through a negotiation phase where the other side says, no, we're not going to pay that, but we see this as being worth this. And during that phase, if we get any offers that the other side gives to us, we always communicate those to you. We can't settle the case without you. And so those offers will go through you, and then we'll go back to the other side. I mean, to some extent, it's not like it's a really, really long, drawn-out process, but that is a stage, a negotiation stage. And if talks there fail, then we proceed to court and we file a lawsuit. And so this is the third phase. We file the lawsuit, and those are fairly patterned. We throw in a few facts that relate to you, but mostly it's negligence, and it's not really that complex to file that. There is a monetary investment, though, that is made in order to file with the courts. It's not cheap to file a case in the court. Then we have the process server, usually the sheriff, serve the other side, the party who is the one that harmed you, and they'll get that. Their insurance company will generally hire an attorney for them. The other attorneys, they always want an extension because that's one of the goals of the defense, is to drag things out. So they always want an extension, and we take those requests on a case-by-case basis. Most of the time, they just answer what's called an answer, and we proceed into the discovery. Every now and then, somebody wants to object to our complaint, and they'll file a motion in Nevada, a motion to dismiss, or in federal court, a motion to dismiss. If you're on the California side, it's called a demurrer. Also motion to strike. And so if the other side files some of these motions, then we have to get in gear and respond to those motions, which may be adjudicated on the papers, or which means without an appearance, or we might have to go into court and actually argue our point. And so that's what's called the pleading stage. All this, where we file the complaint, we start it with the court, and then the other side is filing motions. And after those motions get resolved, if the case isn't dismissed, because sometimes there's just several cycles of that, like you want to know what your attorneys do for you. I mean, I'm envisioning all these things that are done. So if the other side files a demurrer, we file a response to that demurrer, and the judge may say, well, they have a point, but we're going to give you, you, the plaintiff, meaning you, the injured party, leave to amend. So we amend our complaint, and then the other side can demur again. So we go through it all again. But assuming we survive that pleading stage, we move on into the lawsuit, and we start exchanging evidence with the other side. I mean, that's really a nice way of putting it, but it's very formalized, and it's called the discovery phase. You might have heard of this. Discovery's been around as part of lawsuits, I don't know, maybe 40, 50 years. It wasn't always this way, but most states and now the federal courts have a discovery phase. And there's several different types of discovery that we can do. One of the ones that will most significantly affect our clients is the deposition. So the other side has the opportunity to take your statement under oath in a usually occurs in a conference room, an attorney's conference room. A court reporter is there, and they have the right to ask you all kinds of questions that pertain to the accident, and then some on the fringes of the accident that don't necessarily pertain to the accident, but they pertain to things that could affect the outcome. So we represent you at your deposition. That's called defending the deposition. We prepare you for the deposition to show you what's coming so you understand the process. But in addition to depositions that they might take from you, we can take depositions of the other side. So we'll take a deposition of the party or parties that harmed you, and so we do the same thing to them. And they, of course, are defended by their attorneys at the deposition. Usually depositions are civil, but sometimes they can get outrageously crazy, but that's not the norm. We try to keep that from happening, but it's a thing where human beings are thrown into the same room and a court reporter is taking down everything that's said, so you never know what's going to happen. So that's depositions, but there's other things that can happen in discovery too. Most often we have to answer interrogatories. You will be asked questions, we'll help you prepare the answers, and we send those to the other side under oath. And there's site inspections sometimes where if the thing that caused your injury, that caused harm to you, is on private property that we cannot get access to, we'll do a site inspection. And so we'll go there with our expert. We'll take a look at the site to see what it was about the site that caused you injury or didn't cause you injury, because in the end it may turn out that there's no liability for the other side, but we have to go there and look at it. So these are some of the things that are occurring during discovery. And so that's the fourth phase. And discovery can run for like 9 months, a year, 18 months usually is the length of discovery, unless you have a highly complex case, which it can go longer. But and so meanwhile, while all that's going on, you're basically not doing anything. You're just living your life and the best that you can. And we hope you're thriving, because that's our goal, is to get you to thrive after this is over, not just be a damaged individual that moves on into life. We always urge you to move on with your life while we're handling this claim for you. So I hope that's helped you learn a little bit about the process. In another message, we're going to do the other 4 phases of the lawsuit, but today we've just covered 4. If you have any questions about this, you have any concerns about your injury, you think you need some help with your injury, feel free to call us. There's links below. I mean, you know how to use the internet, so I'm sure you can find us. So happy you joined us today, and hopefully this was enlightening. You got some new information today, which is always my goal in spending this time. Again, I'm Tanya Ballard. I'm an attorney in California and Nevada, and thanks for listening.